Good afternoon, everyone. This is attorney Sara Khaki with Atlanta Divorce Law Group, and I'm joined by my good friend and tax guru, Jason Wiggam from Wiggam and Geer, a tax law firm here in Atlanta. Not only is Jason a great friend of mine, but he's my go-to person for all things tax law. He has obviously Juris Doctor's degree in law, but he also has a master's in tax law. So all the credibility in the world to him and everything he is able to help our clients through and everybody here in Atlanta with their tax issues. Jason, welcome.
Thanks, Sarah, for the kind words, and thanks for having me.
Of course. So this is a topic that I think is an afterthought usually when people are getting divorced, which is what are they going to do about their taxes, how to deal with their taxes, what are going to be the tax ramifications of some of the things they negotiated through the divorce process. And unfortunately, a lot of times they come to you when it's a little late, or we refer them over to you when they've already faced these big tax problems. So the point of this conversation is to give some general common sense, best practice advice to couples who are considering getting divorced or are seeing their divorce attorneys right now, some things that they need to keep in mind while they're putting these terms into their settlement agreements, or they're battling so hard for certain terms and in their divorce. And it's just some important things that they can negotiate at the onset, or at least be aware of the liabilities so they can financially plan ahead of time. So Jason, I first want to go through with you our best case scenario. And in our world, in the divorce firm world, the best case scenario is two couples who are on the same page and they feel mutual respect, mutual care for each other, but have come to the decision that they no longer can have a healthy marriage and that they need to transition into a different form of a relationship. And that's when they are usually come to us at that point and they ask for an amicable divorce. They've decided late at night at the kitchen table, this is what you get, is what I get. This is what is going to be mutually beneficial for both of us. And that's the key. Usually that couple that is at that stage, they don't want to screw each other out of anything. They really just want to do what is going to be best for both parties. And in those terms, talk me through a little bit about just general advice you would give that couple when they're sitting down and they're saying, well, you take the house and I'll have primary custody over the children, but you get to come visit them this often. And then here's how much alimony I'll pay. When they kind of have a general understanding of alimony, child support, and the division of assets, what are some things you would want them to not forget and to consider in that general agreement that they're coming up with together?
Yeah, I mean, obviously, as a tax attorney, I'm always thinking about the tax consequences of things, and I think especially when it's amicable, people don't think about that, and and I get it. I mean, taxes suck. I try not to think about them unless I really have to, so I totally get it. But your filing status, if it's married filing jointly versus separately, obviously, the year of divorce, you're not filing together, but if you have any unfiled years, generally you pay less in taxes if you file jointly, so if it's amicable and the parties know everything, that makes sense to me. Maybe they've come up with how the assets are going to be transferred or have a pretty good idea, but they should think about like the tax consequences of those assets. So like, if it's a stock portfolio or a portfolio of investments, maybe there's some built-in gains when you transfer the property between the parties from one to the other. If it's like a joint asset and they're transferring their interest to the person just so they own it by themselves, that's not taxable. That doesn't trigger a gain. It's called a transfer incident to divorce. But when the person receives it, when they sell it, many years later or whenever that is, there could be a gain they have to pay. So that's something to think about and consider when divvying up the assets. There's certain deductions, like you can deduct your children, mortgage interest, and all of these deductions might or might not benefit certain parties. So you should think that through too. And if sometimes you can negotiate them and receive them, and other times you can't. You know, you can't claim the mortgage interest deduction if you're not actually paying the mortgage. You know, but most cases there's some kind of shared custody, and so children could be claimed by either party. So the, you know, the higher income spouse, you know, might view that as a benefit, whereas, you know, if one has a lower income, maybe they don't even get the tax benefit. So those are kind of high level, you know, big things that I think they should think about.
So yeah, let's break those things down, because you did a good job of kind of going over the general issues, and let's take them one by one. So first of all, as far as filing jointly, your general advice is, if your CPA, because hopefully there's a CPA in the picture,
Sure.
If your CPA sees that you could, what is the most typical scenario, which is a joint filing will get a better tax result, whether a lower liability or a refund, they can file jointly even the year that they're going through a divorce. Is that correct?
Not the year that it's finalized. You have to file separately.
Until it's been finalized,
Yeah.
Can't they still file jointly?
Correct. So yeah, we're always filing a year behind. So most people, even if it's finalized in 2021, they still need to file their 2020 taxes. So that's the one where it could matter. Just in general, you know, when you're married, you either file jointly or separately. I don't know the statistics, but a very large percentage of people file jointly. And the reason is the tax code and all the policy behind it is set up to encourage that. The tax rates are better, you get better deductions. You know, like why that is, I don't know. I guess, well, I have an idea, but I won't go into it because it's really boring, but that's just the way it is. And so, you know, there are some situations, which I think we will eventually talk about, where you would definitely want to file separately. But, you know, if you have all of the information and it's just about making sure the divorce estate is as large as possible and, you know, we're all on the same page, I would think filing jointly makes sense. Most tax preparers are going to push you to file jointly. And, you know, most people, I mean, I meet a lot of people who don't even realize that you could file separately. So, you know, that sort of the general consensus there, I think, is right for this scenario.
Yeah.
Obviously, everyone's situation is different. And, you know, I'm just talking, it's a generic, you know, rule. And we're going to talk later, I think, about some scenarios where you definitely would want to file jointly.
Yeah, and we're going to get to the point where the divorce isn't so amicable, and that has its own can of worms, and we'll get to the crazy cases there that I know you've dived into many times. Let's talk about then the division of assets, the most common one being the home. And the general rule of IRS is that if you receive any assets from the divorce order, this is not you don't have to pay taxes on that. Is that correct? It's a deduction?
Yeah. So generally when you like transfer an asset to another person, whether they paid you anything for it or not, that's considered a sale for tax purposes. So, you know, it would normally trigger a gain or a loss. So your house, you know, if you had a $250,000 gain built in, it could be triggered. Here, the tax code set up that transfers incident to divorce are not taxable. So the idea is any transfer within a year of the divorce is presumed to be related to the divorce as long as it's between the two parties. And then any transfer within 6 years, as long as it's covered in the divorce settlement agreement or some court order, you know, negotiated by the parties, and there's a written term, it would be too. So generally speaking, most of those transfers aren't taxable. And if they are, it's because someone waited too long or it wasn't anticipated. But, you know, when someone hires quality family law attorneys like you guys, you know, that's usually not an issue, right?
Well, that's the goal, right? And let's clarify that, because it's very common that, you know, a party has a home, neither party wants to live in the home after the divorce. So one party gets the right to the proceeds from the sale of the home, but so that's all really the divorce order decided, that the home will be sold and the wife will get the equity of the home. And that might take more than a year. And that's why that law has that 6-year window, that in case that within a year of the divorce order, you come across a asset that is from the divorce, you still have that 6-year window to claim it, that this should be tax deductible.
Yeah, and it just applies to the transfer from, the husband to wife, right, or vice versa. So if
not if you sell it or if you get something else from it.
Yeah, and so look, your home, there's another provision in the tax code. I guess we want to encourage people to own homes. So your primary residence, if you're a single filer, you can exempt $250,000 gain, and it's $500,000 if you're married. And I don't have all the particulars, but when you're divorced, you can still use the $500,000 exemption in a lot of cases, as long as it's sold, close to the event. I don't remember the time frame, so I'm sorry about that. But so for most people, your scenario with the home, it isn't taxable unless it's a home they've owned a very, very, very long time, or maybe they're in a really hot area and it's appreciated a lot, but for most people, your primary residence, when you sell it, the gain is exempted due to that provision.
And then child support and alimony, things changed drastically with the tax laws there in January of 2019. So would you mind just kind of giving us that, if your divorce was finalized before January of 2019, what you're looking at if you want to modify, and what you're looking at for anybody after, from then on until now, really, the present?
Yeah, so pre-tax reform, the rule was child support, the payor can't deduct it, and the recipient gets it tax-free. So there's no sort of tax consequence for child support. Alimony was different. The payor, whoever was paying the alimony, could deduct it on their tax return against their income, but the recipient of the alimony paid taxes on it. So I think a lot of the negotiation was, obviously the high income party wanted to get to classify as much as alimony as possible, and maybe the recipient didn't want that income, they wanted to be child support. So that was always an issue, and the IRS would audit people and say, well, that's not really alimony. Or both parties would claim different things on their tax return, and they're having to audit both parties, and it was just kind of a mess. So, when tax reform came around, they said, hey, we're going to treat alimony just like child support. It's not income to the recipient, no deduction, but it created an issue, right? Because the law changed and there are pre-existing orders, out there. So it was only effective January 1st, 2019 forward. So any alimony orders or settlements, anything finalized after January 1st, 2019 are subject to the new rules. So then it created an interesting question. Well, what happens if we modify it? And so the IRS came out with guidance that basically says, if you modify a prior order, you can change the tax consequences, but you have to state it very clearly with specific language in the agreement. So parties can negotiate over that if they're revisiting, if there's a modification. And, I think it depends on the individual circumstances and who has leverage and what they want, but that option is on the table.
And there's another piece too that is negotiable between the two parties as far as the tax code is, and that's back to the child support, claiming the children, right? Who
Correct.
Gets to claim the children as a tax deduction. Do you want to brush upon that real quick for us as well?
Yeah, and basically, as long as either party could, as the parent and the child resides with them at some point, throughout the year, you can negotiate who claims the deduction. It used to be you could just agree to it and it didn't matter if the child resided with the parent at all. Now there are some other strings attached, but for most people, you could alternate years. Maybe if the children do not live with one spouse full half the year but that spouse is higher income, they could still claim them. those kind of things. It's negotiable. But I guess what I see is, even if it's a low-income spouse, how the tax code is set up, there are a lot of benefits, a lot of free money that you receive by claiming children. So the earned income tax credit, the child tax credit. So both parties usually want the deduction, or they don't know. So like we talked about earlier, it's definitely something they should pay attention to, because I've seen I've seen tax returns where it's like, my client makes $35,000, claims 3 kids, and she gets a $7,000 check from the government. That's a significant raise. So you would want to consider that and make sure you don't miss out on that benefit. And then the flip side would be if like say her ex-spouse earned $300,000, $400,000, $500,000 a year, the deduction for the children can be a significant tax reduction for them too. So both parties are interested.
Yeah, claiming the children is a hot topic in our world, the family law world. Yeah. It's a fight. It can be a fight, and hopefully, usually, we're still being amicable. And the default rule is we usually look at the custodial parent, which means the parent who has the primary caretaker gets it, but they can negotiate it out. And to Jason's point, if you have any sort of visitation schedule, you have any sort of time with the children, which is rare that, in most divorce cases where both parents want to be involved, that doesn't happen, that both parents usually do get time with the children. You can negotiate who gets to claim the children, and it doesn't have to be the same parent every year. So it's one of the big issues that can cause a lot of back and forth. Again, if we're in the amicable divorce boat where husband and wife are sitting at the kitchen table in the middle of the night trying to figure this out, that's wonderful, because then they can use this as, okay, I get this, what do you get in return, sort of thing, versus just spending tons of money on tax law and family law attorneys fighting each other to death over this issue. So now let's go to that scenario where it's usually not the ideal scenario. Just one party does not know what's going on financially. One party knows all the bookkeeping, has been on top of all the financials of the house, and it's not an amicable divorce. They're not on the same page. And one party feels like they have the upper hand on what they know about money, and the other one feels really weak. The biggest thing I hear from our clients here at Atlanta Divorce Law Group is, Sarah, I don't even know if he's paid the taxes in the past few years. Sarah, I know that we had bills coming from the IRS. I know for the past 5 years, he's been taking cash out of the business. And it's very, very scary for them. Give me a little bit general information on what do we tell that client, the spouse who's been in the dark and has zero trust that the other spouse has been handling the tax liabilities properly.
Yeah, so like this is kind of the world I play in, I guess, because
this is the part you roll up your sleeves, Jason.
Yeah, these problems come out, and we help. I guess the first thing I would say is I do see scenarios where the person thought it was amicable, and then later they discover information. I don't, obviously, if you have a good divorce attorney, I don't think that would happen. But, I have seen scenarios where everyone thought they were on the same page. Information came out years later, and, maybe they regretted some of the choices that were made when the agreement was reached. But yeah, with your scenario, they know, I think they're not sure if spouse is cheating on their taxes. And what I mean by that is they're typically self-employed. Are they reporting all the income from the business? Are they committing tax fraud? Are they skimming money out of the business, not paying taxes on it? Have tax returns been filed or not? Look, I'm a tax attorney. My wife and I file jointly. I take care of the tax returns and the entire process, and she trusts me. And I have a master's in law and tax. It makes sense, right? But I think there are a lot of people in that scenario that are the same way. They're trusting the other person, and they violate that trust. They don't file, or I've seen where tax returns were filed, but the party's signature was forged on them, and the return is not accurate. So, if you discover these things, you should definitely be concerned for a couple of reasons. One, if you file jointly, or if you've already filed jointly, married filing jointly with let's just call them the tax cheat, with the tax cheating spouse. The downside to filing jointly is the government has the right to collect from either party. So the IRS, even if it's not your income, the Internal Revenue Service can go after you. So what I see is it's typically self-employed spouse, and then the other spouse gets a wage earning job. They're receiving a W-2. So putting myself in the IRS's shoes, it's much easier to collect from the wage earner, the person who receives the W-2. So they tend to get screwed, or at least when they come to me, that's what's happening. So in that case, if they had this information and had a choice, you should definitely file separately. As an economic unit, more tax will be paid, but at the same time, why risk the liability? Why risk their tax issues? You can always amend the tax return from married filing separate to joint. You can't go the other way. The only way say that again.
That is so important, Jason. Repeat that so everybody's very clear.
Yeah. So when you file a tax return and you've made a mistake, you always have the right to amend it and fix it. Okay. It's called filing an amended tax return. So when you've filed married filing separate, you can file an amendment, both parties, to say, hey, we screwed up. We want to actually file jointly. If you start off married filing joint, you cannot amend to separate. That you're not allowed to do that. The only way to remove yourself from liability is to seek what's called innocent spouse relief, which I think we're going to talk more about later. So I won't go into it right now. So, sort of when in doubt, if there's any risk or concern, obviously try to get the other side to give you the information and investigate and see. But if you can't get that information for whatever reason, I would file separately, because the cost to amend, to hire a professional, is probably worth the peace of mind to know that you're not going to get screwed. So that's the first thing. A lot of people come to me, though, and they file jointly because they were left in the dark and they didn't know. So we look at doing innocent spouse relief. I think when you discover a tax issue, because I represent the people cheating their taxes too, sometimes it can be resolved and the parties should try to work together too. And what I mean by that is there's this divorce estate, and if there's money there, it will likely be used to pay the taxes. So both parties have an incentive to try to minimize the tax liability, right? Like let's keep the pie to be split between the parties as high as possible. Now, I've also seen the good work that, attorneys like you do, Sarah, where it's like, that was his fault. We're going to take it out of his or her, his or her share. So it might not necessarily be a concern, but, many times if someone hasn't filed for a number of years, or they made a mistake in not reporting certain income, you can voluntarily correct it and minimize a lot of the consequences of that. And so as long as it's discovered and the parties can agree on what can happen, that's a possibility. If you can't agree, you definitely want to file separately and not get involved with their mess, or try to be an innocent spouse. The other thing we get involved in is, the party who hid their tax issues, ends up getting a tax lien, or there's some ramification of their non-payment of taxes. And, the tax lien's filed against the home. The other party receives the home. Situations like this, you really have to think through, because even though your divorce settlement agreement says you're entitled to the equity in the home, the government's going to get the money due to the tax lien. So like certain transfers incident to divorce, from the divorce could defeat a tax lien, and others might not. It's very fact intensive. The timing matters. So like all of these things have to be considered. And, usually where I start is what's the party's intention? Like, where were they trying to go? And can we work backwards to get there? And, if not, I tell them, and, maybe they want to change course instead of, moving forward to an outcome they don't want.
So let's talk about the innocent spouse defense.
Sure.
Which is, I did not know that he was cheating his taxes. I did not know that she wasn't paying taxes on the cash that was coming in from the business, or that she wasn't claiming the proceeds from the business. As high, because I know that's very fact intensive as well. But from a high level, what can you share with us on that? Yeah,
so there are two types, or two different types of cases. So there is the understatement, which means someone didn't report income, or they claimed like false deductions, like, for instance, I deducted my Ferrari through my business, and, the Ferrari wasn't actually for business purposes or something like that, right? And so the IRS comes in and removes the Ferrari, your income goes up. So in those types of cases, it's really about, did you know about it? So, did the requesting spouse, the potential innocent spouse, did they have access to the business's books? Were they aware that the Ferrari was deducted, right? And then there's sort of an unfairness element too, but that's the biggest thing, that they know about it. The other type of case, which is the more frequent one that we see, is underpayment. So this is where a tax return was filed showing an amount owed and that it just wasn't paid. So much more involved, more factors at play. And so I'll just run through those. And to your point, it's definitely a fact-intensive thing. So no definitive answers here, just kind of high level. But number one, it's positive if you're separated or divorced. Next, like, who agreed to potential responsibility for this? Like, so if it's addressed in the divorce decree or the settlement agreement or whatever, who's responsible? So, obviously, I feel like I'm just repeating myself here, but, good divorce attorneys like Sarah and her firm, they're going to try to have the other side agree to responsibility, which is a good thing. And then knowledge. So here, knowledge is like, did you even know there was this unpaid tax liability? I mean, in most cases, the line that you sign the tax return is right below the amount that's owed. So the IRS's perspective is, if you sign that return, you knew how much, whether you reviewed it or not, you knew the amount owed, right? So, did they actually sign the return? Like most tax returns are e-filed now. So, did they actually sign the e-file form? Did the other spouse forge it? If they were aware that the amount was owed, what were they told? Like, did the tax cheating spouse here say they were going to pay it? Did they enter into an installment agreement? What's the sophistication of the parties? If you do not have a financial education, if you have no prior experience with taxes, if you're generally kind of unsophisticated as to this stuff, which a lot of people are, and it's not a bad thing if you're like that, it's more likely that you would succeed because maybe it's more reasonable for you to believe it was paid, or you didn't understand what it was. Did you benefit from the unpaid taxes? So there, if tax cheating spouse took the funds and used it in a way that the government might view improperly, that's not going to work to your benefit. And if you benefited from the thing, so if you guys took an expensive vacation to Africa or whatever, and you were along for the ride, they're probably not going to look at that kindly. Those are sort of the big factors. And the other thing is, and this isn't in the law, it's just practically speaking, will the other side cooperate? Because in my experience, these cases are, there's very limited information other than what the IRS gets from the parties. So we file this request that's signed under penalties of perjury that tells our client's side of the story. IRS then reaches out to non-requesting spouse, here the tax cheating spouse, to say, hey, we received this innocent spouse request. Tell us what happened. What do you think happened? So, you know, if that person lies or disagrees with what we've said in any way, it's sort of a he said, she said situation, and you're less likely to win. You can still win, but we are likely having to litigate this case. You know, it's going to be more work. Whereas if that person wants you to win, or like many people who have tax problems, maybe they don't open IRS mail, you know, they ignore it, you know, and they don't respond, that could be beneficial. So practically speaking, in some of these cases, maybe the other side wants you to win because it's in their financial best interest to do so. And, you know, that can work to your benefit. So I've seen that a lot, but I covered a lot of ground. So I'm just going to be quiet and let you go now.
No, I think bottom line, if you do find yourself in a situation where you need to claim, you really believe you may have a innocent spouse defense, that's not a situation to go out on your own. You need to look into hiring a firm like Jason's firm and help them give you best case and worst case scenario. That is, you're not going to be saving money on that one, trying to go at it on your own. You're going to be in a much worse situation. You've given a lot of good advice, and some of it I think.
Can I say one thing real quick?
Yes, please.
Quick story. So I get a lot of clients that started the process without us. You know, maybe they self-prepared the innocent spouse form and they're rejected, and now it's time to appeal or go to the U.S. tax court. Then they engage us, or their CPA or their tax preparer, someone started the process. And yes, much better to engage us from the beginning, because a lot of people aren't experienced with this and don't understand, and there are a lot of traps for the unwary. And I've just also seen a lot of really bad advice. I mean, we had a case where the advice given after the initial rejection was, well, you know, this is a waste of time. You shouldn't keep moving forward. And the client had never done this before. They were, you know, unsophisticated, so they believed this person. And so they didn't appeal. And there are time frames that if you miss them, you're done. It's over. And so her federal innocent spouse claim failed, and, you know, we couldn't, like, it was done. And before this person even came to us, but we were able to do an innocent spouse case with Georgia, and we won. And I told the client all along, I'm like, look, we could have gone to tax court. I mean, I couldn't have guaranteed success, but they had a really good case. I mean, the perspective of the other professional, in my humble opinion, was just wrong. So I just wanted to quickly mention, you know.
No, I'm glad you mentioned that, because I want to ask you if this is true for the IRS. My experience with most government agencies that have their own adjudication process is that they typically rely on denying and hoping that people either don't appeal or don't know what they're doing, or they don't go get representation, and that they're just going to drop off. They don't really truly look at your application or your request to be heard. A lot of these agencies give you rubber stamp denials in the initial appeals process, hoping you back off, you get intimidated, you get overwhelmed, because they're overwhelmed, right, with all the bureaucracy and all the paperwork. So an easy way for them to sort of weed through this and say, denied, 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 and they know a high percentage of people who are seeking these reliefs will look at a no from the government and will give up, or will not have the foresight or the sophistication to question it, or go get an attorney like you to say, hey, this needs to be appealed. But here's what's concerning when you start that initial application on your own is that's part of the file, right? If you didn't hire Jason's firm to file that initial innocent spouse application, whatever you put in there becomes part of the file. And then you make, I mean, as Jason just shared that story, his firm can still come in and win the appeal for you, but you've now created a more of an upward hill battle for them to undo anything that was in your initial application that you put in without the advice of counsel that could bite you in the arguments that you want to make for your defense.
Yeah, I want to control the narrative from step one, because to your point, someone could say something or admit something that they didn't necessarily need to, and maybe it was well intentioned, but they hurt their case, you know. So yes, you're exactly right. And just quick comment: the IRS's policy isn't to deny everything, but there are certain offices and parts of the process that are less friendly than others. So we definitely take that in consideration. For example, you have an you have initial determination that you can, which many people win at, by the way, a lot of cases in there, but that's our goal, to win it there if we're submitting it from the start. But, you know, it's accepted or rejected. If it's rejected, you can appeal, and you have a certain time frame to do so, and it's an administrative hearing. We generally don't do that right now. I used to, and the policy, you know, we're talking today, July 22nd, 2021. So if you're seeing this in the future, maybe things change, but right now, it's sort of a waste of time and legal fees and effort to appeal. I mean, we still will if it's like a real clear case or something, but, you know, if it's discretionary, the office that sees these appeals pretty much rejects everyone. So you can bypass that and just go straight to court. And so we do that. And it's literally because we care about our clients and want to save them money. You know, it's like, hey, look, I love litigating. I love doing administrative hearings, but I'm only going to do it if it's in the client's best interest to do so. You know, it's like, why spend $5,000 in legal fees to do a hearing that we all know you're going to lose? That's not necessary, right? So, you know, I find that people don't always believe me. You know, I'm like, hey, let's just go to litigation. I think they're thinking, oh, you're an attorney, you want more billable time, it's going to be more expensive. That's not really what's going on. Yeah.
No, and I can testify to that because, you know, our law firm used Jason's team to help us through the SBA, PPP, forgiveness, all the crazy applications. And that's exactly the approach you guys have taken with us every step of the way, is how to give us the optimal results without us spending billable time, your billable money, and spend money on it that wouldn't be necessary. So that's you definitely stand out with that mentality. Let me ask you one other scenario. Anything that we need to share or put into consideration for a family that's going through an audit while they're going through divorce?
Yeah, that's a good question. So, and we have a few of these right now. So yeah, when you're under audit after divorce, yeah, they want to talk to both parties. And so the situation we have is, you know, typically when you have like the full-blown audit where there's a human being assigned and they want to interview you and go through your bank records and, you know, the whole process, you know, they're going to want to talk to both parties. But here the auditor has told us that she is focused on a business, and it's not my client's business, and my client has no access to those business records. So, you know, we just got involved and we're like, look, we're here to cooperate, but there's really nothing for us to give you. You know, happy to answer any questions you have, but, you know, you need to talk to the other person. Now, they filed jointly. So obviously we're very interested in what happens because maybe she has an innocent spouse claim, right? If her husband didn't report everything, her ex-husband didn't report everything correctly. But yeah, you still need to participate in the audit, and, you know, which my suggestion would be hire a representative, you know, your qualified CPA or an attorney, to at least talk to the government agent on your behalf. And you're going to want to know what's going on, even if it's the other party's like income items or issues, because if it's a joint filing, you're going to owe it too. And you can assert an innocent spouse claim out of an audit. You can assert it to the auditor. You can assert it in tax court litigation. So when you're audited and the government says you owe money, they are wrong. quite often. We make a lot of revenue. We earn a lot of revenue disputing IRS auditors' determinations, right? So you can appeal it, you can go to court, you have all these due process rights before you actually owe the money. So you can take advantage of those before you ever owe it to assert defenses. So you, even if you think it doesn't apply to you, you should participate to make sure your interests are protected. And then, you know, I guess on the flip side, if you're the person that's sort of the target of the couple, and you're in trouble, I mean, definitely hire a representative. You're if you've never gone through an IRS audit before, it's not something that you're going to become an expert at and learn on your own dime, right? So definitely hire someone who's qualified to handle it.
That's good advice. So just to wrap up here, Jason, I want to kind of point out some of the most important things that I think people need to take away from this, and correct me if I get any of it wrong. You have an amicable divorce and you're sitting down with your spouse at that midnight kitchen table and thinking through what are the things we need to put onto our settlement agreement. Don't forget that who claims the children can be negotiable. Don't forget that the house, if it has any liens on it, if it has any tax liability on it, on any of your assets, have any liens on it, it will impact the person who ends up gaining it after the divorce. Since the January 2019, alimony is not a tax deduction and it's not a tax liability. Child support is not taxed and it's also not a deduction. And I think that's the main things for the people who are sitting down and thinking through it. Of course, there's always the nuances and the specific facts, but just from a high levels, some things to consider.
Yeah, no, great summary.
And then also remember Jason's point that any asset that you gain within a year of the divorce is automatically considered a gain from the divorce. So it's not tax deducted. It's not, you're not going to have to pay taxes on it. It's not
Make sure you tell your tax professional, you know, they're not going to automatically, maybe they won't put two and two together, right? Make sure you say, hey, this relates to my divorce when your CPA prepares the return. Or if you're using TurboTax or whatever.
Yes. And but you could still make the argument up to 6 years after divorce. And then we have the cases where you don't know what's going on with the other spouse, and there could be tax liabilities. There could be years of taxes that have not been paid, tax fraud going on. That I like Jason's term of the cheating tax spouse. If you suspect you are with the cheating tax spouse, I think the best advice you gave is file separately, and you reserve the right to amend later to file jointly, and you cannot do the reverse. You cannot start off in that situation and file jointly and then later on decide, oh crap, I'm going to get in trouble, so now I'm going to go and file separately.
Yeah, and one quick thing I forgot to mention on that. So what I see a lot of the time is, you know, people don't know about filing separately. So, you know, one spouse has all of their tax documents ready to go and they're waiting on the other one who's procrastinating. You don't have to wait. You can just file separately, right? You can move forward. You know, when I deal with the IRS, I get this a lot where that spouse is like, well, hey, I did nothing wrong. You know, I was ready to go and he or she wasn't. That's not an excuse they're going to accept. You know, whether you know about filing separately or not, they're going to say, well, hey, you could have just filed separately. So I think in many cases, best to just cover yourself and not worry about the other person.
That's really good tip, because it's also very common in our office that we see one spouse that's just so done and wants to clean their hands of everything that still is, you know, tying them to each other. And this is sort of a good peace of mind for that spouse to know that you can go ahead and file on your own and move on. And you don't have to feel still tied to them because of this tax issue. And then really finally, if your divorce was finalized prior to January of 2019, see a family law attorney who to prepare your modification if that's what you're seeking, so they can put the specific language that Jason talked about on how you want the tax treatment to be handled under the new law, or go back
if you
to
want
the way
to
it used to be.
Only if you want to change, yeah.
If you want to change it, yep. Jason, do you think, is there anything else we need to give for people to consider?
No, I mean, I think
other than the fact that they're in trouble, call Jason now.
Yeah. I mean, sometimes we can handle issues in a short paid consultation if it's not a problem, or maybe there is a problem, and getting someone involved early before it gets worse is really important.
We will share Jason's office's information in the comment section for those who want to get a consultation or want to look into getting tax relief or tax help through their firm. And like I said, highly, highly recommend them. The level of integrity has been unmatched, truly. And I know a lot of people that do what you do, and you're one of a kind. So I appreciate that. And I also appreciate you getting so many people through 2020 with all your excellent tax and PPP and SBA EIDL mess advice. And you stayed cool when the rest of us were losing it. So thanks for being the calm in the storm there. Yeah,
look, I might look calm and collected and even keeled, but inside it's not always like that, to be fair. But I'm glad we were able to help so many people and help you. And
you're like the Men in Black of time. You make it look good.
Thank you.
All right, Jason, we'll have a wonderful rest of your afternoon. Thank you for spending your lunch with me.
Thanks. Bye.